Hello, I'm Jared Karchner with the Northern Virginia Estate Planning Law Practice, and today I'm going to talk about the different business entities available to you under Virginia law. You've decided to go into business, and one of the first questions you'll need to ask yourself is how you want to structure your company. What business entity do you want to use? To answer this question, you first need to know what business entities are available in Virginia. And when making the choice of how you want to structure your business, you need to consider a number of factors, some of which I'll discuss here, such as who will be responsible for establishing and managing the business. How do you want to limit your personal exposure to the company's debts? How do you want the company's profits to be taxed? Does the type of business you want to operate have restrictions on how it can be organized or operated? How important to you is privacy? What public reporting requirements are you comfortable with? Is the company a standalone business, or will it be the subsidiary of another company? How do you anticipate funding the company? Do you expect that the company will be traded publicly? As you can imagine, there's no perfect way to organize a company. Each of the following choices have advantages and disadvantages. While the choice doesn't have to be permanent, there can be disadvantages to changing the form of the business once it's been established. The ideal is to make the best choice as a compromise between the circumstances at the beginning with an eye toward what the successful business will look like in the future. So here are some of the most frequently used business entities in Virginia with a brief snapshot of each. First of all, we begin with a sole proprietorship. This is the easiest way to get into business. Other than acquiring any necessary business licenses and certifications and registering a fictitious business name, if you want to operate your business under a trade name, you're good to go. You control the business, and the income the business generates is included on your personal tax return. Unfortunately, doing business as a sole proprietor provides you no liability protection, and your assets, even those not linked to the business, are at risk if things go south. Next is a general partnership. A general partnership is formed by two or more people to carry on a business. While no official filing is necessary, a partnership is generally established by a written partnership agreement that defines the rights and the responsibilities of each of the partners. The partnership is not taxed separately, rather, the profits or losses of the business are passed through to the partners and reported on their personal tax returns. This is a situation referred to as pass-through taxation. On the liability side, each partner is personally responsible for all of the obligations of the business, even when just one of the partners incurs the debt on behalf of the partnership. The partners can also be liable for the company's obligations beyond their investment in the company. Now, on the other hand, a limited partnership, an LP, addresses in part the liability concerns of the partners that exist in a general partnership. An LP requires at least one general partner and at least one limited partner. The general partner manages the business and assumes responsibility for the partnership's liabilities. The limited partners invest in the partnership but can't take an active role in the management of the business. In exchange for limiting their control over the business, their potential losses are limited to the amount they've invested in the LP. All partners enjoy pass-through taxation. The next thing would be the Limited Liability Partnership, or LLP. In an LLP, all the members of the partnership can play an active role in the management of the company, and yet they all enjoy limited liability, and all partners enjoy pass-through taxation. Then we come to the C Corporation, or C Corp. Establishing a corporation entails a fairly formal process that includes filing articles of incorporation with the Virginia State Corporation Commission. Establishing a corporation creates a legal person independent of its owners. As such, the owners, i.e. the shareholders of a corporation, are not liable for the debts of the corporation. The downside is the issue of double taxation. The corporation pays taxes on the profit it earns, and then the shareholders are taxed again when the corporation pays dividends out of these profits. An S corporation, or S Corp, from a legal perspective, there's no difference between establishing a C Corp and an S Corp. The process is the same. The S Corp is simply a C Corp that the owners have made an election with the IRS to treat the corporation differently for tax purposes. And by making this election, the IRS treats the S-Corp as a pass-through entity, avoiding the double taxation issue. In turn, however, the IRS places a number of restrictions of the corporation, including how many shareholders the corporation can have, whether they can be non-natural persons, the nationality of the owners, etc. The next thing is the beneficial corporation, or B Corps. These were first introduced in Virginia law in 2011. They're regular corporations that must have general public benefits, such as public welfare, religious, charitable, scientific, literary, educational purposes, or other benefits beyond the interests of the B Corp's owners. Now, B Corps are taxed the same as C Corps or S Corps depending on their election with the IRS, but one of the primary advantages of a B Corp is that the boards and directors are provided protection from shareholder lawsuits when they pursue the objectives of their social mission over strict shareholder value. And then we come to the Limited Liability Company, or LLC. LLCs are also relatively new. They're a bit of a hybrid of a C Corp and a partnership. While it still requires a public filing with the Virginia State Corporation Commission to be organized, the paperwork is less formal and provides the owners much more flexibility. It provides the limited liability of a C Corp and the pass-through taxation of a partnership without the restrictions of an S Corp. And for these reasons, particularly for smaller and or closely held businesses, LLCs are increasingly becoming the business entity of choice. And then we have the business trust, and this is not to be confused with a living trust as used in the estate planning context. A Virginia business trust is an entity where the trustees operate the business on behalf of the beneficial owners. And one of the primary advantages of the business trust is the ability to establish any number of series under the business trust that act as independent companies. There are a number of scenarios where this becomes advantageous over an LLC. For instance, a real estate company with multiple property holdings can establish a single VBT, but hold each individual property in a separate series under the umbrella VBT. And in this way, each property is isolated against claims arising from any other property in the VBT. VBTs also benefit from increased confidentiality. The beneficial owners don't need to be disclosed in public filings. So in summary, Virginia offers a broad array of choices on how you can structure your business entity. They each have their own advantages and disadvantages, but by and large, the LLC has become the most popular entity due to its ease to establish and operate. Still, you should take into account your own circumstances before deciding which entity works best for you. So that's it for today. If you have any questions, you can look at my website at novaestateplanning.com or shoot me an email at jared@novaestateplanning.com. Thanks for watching, and I'll see you soon.